Senate can come back to order. The Senate can come back to order. We will be continuing down the rules calendar, and the author of Senate Bill 200 be on standby. Next bill on the docket is Senate Bill 200. Secretary, read the caption.
Senate Bill 200 by Senator Cowsert of the 46 and others, a bill to be entitled an act to amend Code Section 91126 of the Official Code of Georgia annotated, relating to general provisions governing discovery under the Civil Practice Act so as to provide for a party or current or former high-ranking government or corporate officer of whom a disposition is sought to seek a protective order. The Senate Committee on Regulated Industries and Utilities recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Cowsert of the 46th District Chairman.
Start reading.
Regulated Industries and Utilities offers the following substitute to Senate Bill 200, a bill to be entitled an act to amend Code Section 91126 of the Official Code of Georgia annotated, relating to general provisions governing discovery under the Civil Practice Act so as to provide for a party or current or former high-ranking government or corporate officer of whom a deposition is sought to seek a protective order, to require a court to prohibit such deposition subject to exceptions, to provide such exceptions, to provide for modification or vacation of orders upon such motions, to provide for an effective date and applicability, to provide for related matters, to repeal conflicting laws, and for other purposes. Section 1, Code Section 91126 of the Official Code of Georgia annotated, relating to general provisions governing discovery under the Civil Practice Act, is amended in subsection C as follows. C1, protective orders upon motion by a party or by the person. That concludes the order, Mr. President.
Senator from the 46.
Thank you, Mr. President. I move that we table Senate Bill 200. I think the majority leader may have another motion.
All right. The author of the bill, Senate Bill 200, has moved that we table his bill. Is there objection? Without objection, Senate Bill 200 is tabled. Senate, moving down the calendar, Senate Bill 204. Secretary, read the caption.
Senate Bill 204 by Senator Dolezal of the 27th and others, a bill to be entitled an act to amend Chapter 14 of Title 20 of the Official Code of Georgia annotated, relating to education accountability so as to provide for the recognition of certain accrediting agencies as evaluators of the quality of education offered in public schools in this state. The Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Dixon of the 45th District Chairman. Senate Committee on Education and Youth offers the following substitute to Senate Bill 204, a bill to be entitled an act to amend Chapter 14 of Title 20 of the Official Code of Georgia annotated, relating to education accountability so as to provide for the recognition of certain accrediting agencies as evaluators of the quality of education offered in public schools in this state. That completes the order, Mr. President.
Recognize the senator from the 27th to speak to the measure.
Thank you, Mr. President. I bring to you Senate Bill 204. A number of you that were on the Education Committee last year may remember former Senator Tippins bringing this bill before us, and I pick it up and just want to honor him as the originator of this idea. We since have worked with the largest accrediting agency in the state of Georgia and have reached a compromise with them, and that is the piece of legislation that you have before you. This bill establishes recognized accrediting agencies in the state of Georgia and really defines the things that they're able to consider in accreditation. And you will find there's only two elements that we are adding here as the considerations for accreditation. The first one is on line 61, and that is the quality of learning and teaching. And then secondly, on line 69, financial efficiency. Part of what we worked with the accrediting agencies on was the establishment of the percentages, and we allow the State Board of Education to establish the percentages, provided that quality of learning and teaching shall not be less than 65% of the consideration. And the other thing that we did, and this was a passion of Senator Tippins, is we ensure that those doing the accrediting cannot offer for a fee additional services to cure the problems that are found in the accreditation process. So part of what I think what was happening before is certain problems would be identified by the doctor, if you will, and the doctor happened to be the same person as the pharmacist who would sell you the cure for a fee. And we want to ensure that the accreditation process is free and clear of any financial consideration for what may happen during the accreditation process. With that, Mr. President, I'm happy to answer any questions or yield the well.
You have no questions, Senator.
Thank you, Mr. President.
Does any other senator wish to speak for or against the bill? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. Secretary will unlock the machines. On the passage of the bill, the yeas are 52 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Moving on, Senate Bill 211. Secretary, read the caption.
Senate Bill 211 by Senator Hickman of the 4th and others, a bill to be entitled an act to amend Title 20 of the Official Code of Georgia annotated, relating to education so as to establish the Georgia Council on Literacy, to provide for consultation with subject matter experts, to provide for automatic repeal, to require local school systems to develop and implement 5-year literacy plans for such school system and individual literacy plans for students in kindergarten through grade 5. The Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Dixon of the 45th District, Chairman. The Senate Committee on Education and Youth offers the following substitute to Senate Bill 211, a bill to be entitled an act to amend Title 20 of the Official Code of Georgia annotated, relating to education so as to establish the Georgia Council on Literacy, to provide for definitions, to provide for members and officers, to provide for meetings, agendas, quorum, and compensation. Senator Hickman of the 4th offers the following amendment, Amendment 1, to amend the Senate Committee on Education and Youth substitute to Senate Bill 211, replacing lines 43 through 45 with the following: Regents of the University System of Georgia, see 2 individuals with knowledge, skills, and experience in birth to 5 years old early learning. That completes the order, Mr. President.
Recognize the senator from the 4th. Speak to the bill.
Thank you, Mr. President. This is such an unbelievable bill that we need to start looking at education in Georgia as an investment and not an expense, and that's what we're trying to do with this bill. Senate Bill 211 is a priority for both the Democrats and Republicans. This is an exciting and important bill because this bill is for generations to come. Creates a Georgia Council on Literacy. And first of all, I'd like to thank the Higher Education Committee, 13 members, and also the Education Committee, 10 members, for meeting over 2 weeks and hearing 15 different speakers talk about and confirm that we have an illiteracy problem in Georgia. We have in the 3rd grade in Georgia over 57% of our children or students are not reading on 3rd grade level. We will never create an educated workforce if our children can't read. On your desk today, we have 2 endorsement letters, one from the Georgia Chamber of Commerce endorsing Senate Bill 211, and we have a letter from the Georgia College and State University of President Kathy Cox from the Sandra Deal Center for Early Language and Literacy endorsing our bill. This bill was patterned after the former Governor Nathan Deal's criminal justice reform bill. You know, you all heard us talk about that our literacy rates are not in line with our graduation rates. Our graduation rates are 85, 90, 95%, and our literacy rate, you just heard me say, for 3rd graders in the state of Georgia is only 43%. Something is wrong there. What are the areas that this bill is going to address? We're going to look at pre-K, pre-kindergarten, and kindergarten, basically birth to 5 years old. We're going to try to come up, no, we're not going to try it, we're going to do it. We're going to come up with a common metric system for measuring literacy in Georgia. Every organization you talk to that we met with, or it seemed like every organization that we met with on these 15 had different types of metrics. We got to come for accountability purposes for our school system. We've got to be able to measure literacy. One of the most important things, we also going to find out if our teachers are being taught how to teach children how to read. And if they're not, we got to help those teachers be developed. And probably to me the most sad thing there's a lot of sad things about what we found out, but we've got to get our communities involved. And I really believe if our communities knew the illiteracy rates in Georgia, our communities would have already involved if our school system would have reached out and have been honest and forthright with our communities. Yes, Senator from the 36th, well, she's not even here. We are going to address ESOL, English as a second language, and economically disadvantaged children. And yes, Senator from the 42nd, we're going to address dyslexia. You know, we had no idea until we got into this that we got 22% of our children in Georgia experience some form of dyslexia. And even my schools, my county, Bullock County, does not address the need for help children with dyslexia. So 22%, well, yes, we're going to address that. Mr. President, this time I would yield a will for questions. Or yield a will.
You do have a few questions, Senator. Senator from 52nd. Well, Senator from the 52nd, you want to come up front? Okay.
Okay.
Senator from the 39th, do you have a question?
Senator, do you yield?
Yes, ma'am, sure do.
Isn't it true that the first step in solving a problem is to identify it?
That is very, very, very correct.
Do you further yield?
Ma'am?
Do you further yield?
Yes, ma'am, I do.
And isn't it true that while this may not address the issue in its entirety, that it is a first step towards making sure that Georgia is changing its literacy rates and that we're putting the attention on this issue that it so well deserves?
That is true also.
Thank you very much. I appreciate you bringing this bill forward.
Thank you, ma'am.
You have no further questions, Senator.
Thank you, Mr. President. Please vote green, yes. Very important. This is an investment in generations to come. Thank you.
Recognize the senator from the 52nd. You'd like to come speak in the well?
Thank you, Mr. President. The rookies around me are rubbing off on me. I guess I'm hitting the wrong button and getting distracted. But I want to speak here in support of this study committee, but I also want us to move forward quickly on this. I think we have information where we can move forward. We see a good program at the pre-K level, and we are now changing the class size to 20, which is a good step. We don't see that at the kindergarten level. We see a drop-off. We have a low reading level at the 3rd grade, and those students are 4 times as likely to drop out if they don't have that comprehension there. We've got to do this early. We have evidence from Mississippi. They're doing a strong phonics program, and it's working. We are doing a good program at kindergarten. We need to do a good phonics program. I'm sorry, at pre-K we are, and at kindergarten we need a good program. And we also need to put something in there that says that those students in pre-K may need an extra year. We see that with our private schools a lot, where they hold people back a year. And we need to be diagnosing for dyslexia at a much earlier age, and those may need to be held back a year. We've got to get a hold of this. I think we know what will work right now. And I hope we will move forward quickly on this, because we can't be getting behind others as we have. Let's not study it real long. Let's move forward with the answers we've got. If there's no questions, I'll yield the well.
You have no questions, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of Amendment 1, authored by Senator from the 4th. Is there objection to Amendment 1? Chair hearing none, Amendment 1 is adopted. Question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute is amended. As amended is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 55 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary will read the caption for Senate Bill 230.
Senate Bill 230 by Senator Brass of the 28th and others, a bill to be entitled an act to amend Chapter 5 of Title 49 of the Official Code of Georgia annotated relating to programs and protection for children, so as to revise provisions relating to the Foster Parents Bill of Rights, to provide for definitions, to provide that such rights include relative caregivers and fictive kin. The Senate Committee on Children and Families recommends that this bill do pass. Respectfully submitted, Senator Kirkpatrick of the 32nd District Chairman. That completes the order, Mr. President.
I recognize the Distinguished Rules Chairman, Senator from the 28th, speak to the bill.
Thank you, Mr. President. Senate Bill 230 is the Foster Parent Bill of Rights, which was passed almost 20 years ago. This bill updates and strengthens the law, expands it to other caregivers of children in de facto custody, and clarifies that foster parents can seek advice and assistance from attorneys and certified volunteer advocates if they have concerns about fostering or about a child in their care. With that, I'll yield for questions.
You have no questions, Senator?
Well, I'll also add, too, and I know this is going to come as a shocker, but one thing you'll notice is not in this bill or does not accompany this bill is a green page. That means we got it right the first time, so I would appreciate your support. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is the objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Senate Bill 246. Secretary, read the caption.
Senate Bill 246 by Senator Hodges III and others, a bill to be entitled an act to amend Chapter 10 of Title 49 of the Official Code of Georgia annotated, relating to the Georgia Board of Healthcare Workforce so as to provide for student loan repayment for certain nursing faculty. The Senate Committee on Higher Education recommends that this bill do pass. Respectfully submitted, Senator Hickman of the 4th District Chairman. That completes the order, Mr. President.
Recognize the senator from the 3rd to speak to the bill.
Thank you, Mr. President. Colleagues, I rise to present Senate Bill 246. This is a governor's priority bill, and it's also a workforce development initiative. In Georgia, as in the nation, we have a nursing shortage. One reason for the shortage is that we don't have enough nursing instructors. Nurses have found that they can make less money teaching than they can practicing, so we're not turning out enough nurses, thereby adding to the problem. Senate Bill 246 incentivizes nurses to teach rather than practice by establishing a student loan repayment plan for nurses who choose to teach. Our budget has $1,050,000 in line item, which will be, under this bill, administered by the Georgia Board of Healthcare Workforce under the Department of Community Health to administer the program and to set up rules and regs. This bill would allow teachers to have up to $100,000 of student loans repaid over a period of 5 years as long as they continue to teach. And this program would be funded annually at will by the legislature. Mr. President, I'll yield for questions.
You have no questions, Senator.
Thank you. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. Opposed, nay. Secretary, unlock the machine. On the passes of the bill, yeas are 55, and I was wondering where our man from the mountain area had been. The nays are 1, so this bill, having received the requisite constitutional majority, is therefore passed. Welcome, Senator back there. All right, I was wondering where you were today. So, Secretary will read the cash transfer of Senate Bill 254.
Senate Bill 254 by Senator Brasso, the 28th, a bill to be entitled an act to amend Chapter 1 of Title 10 of the Official Code of Georgia Annotated, relating to selling and other trade practices so as to provide requirements for earned wage access services, to provide for fees that may be charged for such services, to provide that earned wage access payments are non-recourse and are not loans. Senate Committee on Banking and Financial Institutions recommends that this bill do pass by substitute. Respectfully submitted, Senator Summers of the 13th District Chairman. The Senate Committee on Banking and Financial Institutions offers the following substitute to Senate Bill 54, a bill to be entitled an act to amend Part 2 of Article 15 of Chapter 1 of Title 10 of the Official Code of Georgia Annotated related to the Fair Business Practice Act of 1975 so as to provide requirements for earned wage access services. That completes the order, Mr. President.
Recognize the Senator from the 28th. Speak to the bill.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I bring you SB 254. This is the Earned Wage Access Bill. And many of you are probably thinking, what is earned wage access? Or what is earned wage? I'm going to tell you. If you look at lines 18, we simply define it as an earned but unpaid wage, meaning salary, wages, compensation, or other income that have been earned by or accrued to the benefit of the consumer, but that have not, at the time of earned wage access payment, been paid to the consumer by an obligor, which is the employer. And there's what we're doing in this bill. Number one is we're putting up we're defining the industry. This is a brand new industry to this state and really to this nation. And so what I wanted to do was number one, define it, put some definitions out there, make sure that consumers know this is not a payday lending. This is money they have earned. They just simply haven't been paid on it yet. And an example of why someone might need it is, maybe you're 2 days away from getting paid, but you've worked a week and a half worth of wages that you're about to be owed, and maybe you need some gas money so you can get to work. Or maybe you need a $50, $75 to keep the lights on at home. And so it's simply a way that we can allow some of these consumers that may be traditionally underserved get access to money. And we're putting up parameters. We've defined what earned wage access is. We've defined what the different business models. There's a direct a direct to business type model. There's a direct to consumer type model, and so we're defining that in this legislation. And then we're also, if you're doing consumer elected fees, meaning the consumer actually picks how much they're going to pay, and we define that. If there's a mandatory fee, that's where we put in a cap of 10%, to where the service provider can't go over that 10%. Currently, under all models in this state, there are no mandatory fees, so no one's acting there. But should they ever switch to that, I wanted to go ahead and get that defined, and that's why one of the reasons that this is important that we go ahead and get this legislation moving for this brand new industry. And one important thing to know is there is no recourse should a consumer not pay this back. I'm sure there's thousands of questions out
You do
there.
have a question, Senator. Senator from the 20th, you wish to ask a question?
Thank you, Mr. President. Esteemed Rules Chairman, how does the earned income lending company collateralize the loan, or is it essentially just a signature loan?
No, so if you'll look under consumer elected of fees, what we're doing there is we kind of lay out the different models. So in a direct to business model where they go work directly with the employer, and that's what they do that's how they verify the wages have been earned, is working directly with that employer. So in that model, they might have what's called a expedited fee. So the consumer can ask to go ahead and get that money expedited. They pay like $2.99, and they're able to get that. But that is if they don't have to get it expedited, so they don't have to pay that fee. There's other models, the direct to consumer, where again, this is a consumer elected a fee, and what we define it as is you actually, the consumer sets how much they're going to pay. In order for it to be consumer elected fee, there has to be an option of $0. And so if I've never done earned wage access, and hopefully I never need to, but last year when this came about, I kind of laughed at the notion that you could set it to $0, and then I took part in a GoFundMe, and to that date I had never even been offered to pay a fee for GoFundMe. You just kind of pay the money, you donate the money, and it's over. Well, they started doing this consumer elected fee to where I could set that fee at $0. I could put it at 5, 10, or I could do a percentage. So that's how they monetize. That's how they make the money, is on those consumer elected fees. Should they want to shift to a model where there's a subscription or there's a mandatory fee of, let's say, if you're going to borrow $100, or not borrow, you're not borrowing it, you've earned it. If you're going to draw down that $100, the most they could charge you is $10. So that's how they monetize it. So there's the mandatory, which has a 10% cap with no recourse. And then there's the consumer elected fee, where the consumer actually picks how much they want to pick, or how much they want to pay. And believe it or not, a lot of consumers do elect to pay a fee, but they must have the option. In order to be a consumer elected fee, there must be a $0 option. Does that answer? I know that answers your question.
Yes, one of my questions. This
Yes,
is
I
an
do.
interesting concept. Would you yield for another question?
Oh, of course I would, to my good friend from the
So
Perry.
if they are working directly with the employer, then the employer, I assume, would, instead of paying the employee the amount that they borrowed from this earned income lending company, they would pay that directly to the earned income lending company? Is that what I'm understanding?
That's not my understanding of that business model. I thought my understanding is the employee still receives his wages or her wages, and then they turn around and pay that money back.
So back to my first question then, if you don't mind a further yield.
I'll yield.
It sounds like a signature loan to me, like there's no collateral. If
That, well, that's, that, yes.
Okay.
Then in that case, yes. It
Thank
could
you,
be
Senator.
similar. Any further questions? I'll be more than happy.
You do have a few questions.
Okay,
Senator.
bring it.
Senator from the 19th, you wish to rise for a question?
Thank you, Mr. President. Senator Yield.
Of course.
Senator, first, this is a green sheet, so does that mean that you didn't get it right the first time?
I will admit that I did not get it right the first time.
Second serious question. I'm looking on line 61. I understand what you say about non-recourse, and my concern is that these essentially turn into payday lending with a set fee at 10%. But when it does say non-recourse starting on line 61. It says you can't initiate a suit, use third parties to collect, sell outstanding debt, etc. But it says except in the case of fraud by the consumer. My question, which I'm sorry to ask you this for the first time, I know you and I have talked about this bill, is if you sign saying you will pay it back and you don't, is that fraud that then will allow you to move down to line 65, 66, and 67 to bring that suit for collections?
No, the fraud would be more on the fact that you say you're working, but maybe you're not. Maybe you set up a fake email account. Maybe you're driving. Because one of the, also in the bill, we lay out the different methods that they can use to verify your work status. And some companies, the direct-to-consumer model, a lot of what they use is they use geospatial data, making sure they're going to work. They use timesheets. They use emails. And so you could the consumer potentially could produce a fake email, could produce fake timesheets, could drive to their place of employment and drive home or go leave their car there, and that would be the fraud. I know you don't like the fact you can't sue, but I'm sorry.
Senator from the 32nd, do you wish to rise for a question?
Senator, do you yield?
I yield.
I'm trying very hard to understand this, and I would like to ask you, so I'm short 1 week, and I borrow money from the money that I've earned.
It's more of a draw than a borrow, because
Okay.
you've earned it.
Okay, sorry about that, a draw.
It's okay.
So what if I want to take another draw the next week? Is there an end to it? How far can you go?
So some companies, some earned wage access service providers, they have an internal policy cap on what percentage of that you can draw down. You know, I know of one specifically. I think they're at 40% of your earned wages that you can draw down. So if you've earned $1,000, $400 would be the most you could draw down that week.
Okay, thank you, Senator. Do you further yield?
Of course.
I'm just trying to understand how people who are living paycheck to paycheck, would this not eventually make it easy for them to get into trouble financially?
It could, but these people it's a similar market to folks that are going and titling off their cars, and so this is another option, and in my opinion, my humble opinion, maybe a little bit better option that allows them to get, essentially a draw on their pay that they've earned, because a lot of people in this market can't go out and do a $2,000 loan, or don't want to, or shouldn't be going up and putting their title up on their car, and but can't necessarily borrow money, and so we're essentially letting them draw down the money that they have earned. You'd hope that it doesn't become a weekly thing. You don't want it to become a weekly thing, but if that's why we need the bill, so that we can have these consumer protections on the front end versus what we've seen in other industries where, it goes unchecked. And again, this is brand new industry. There are bills floating around the entire country. Nobody's been able to pass one yet. Georgia could be the first. And I've got it down simple. I've got it down where both business models are at least in somewhat agreement. And we're trying to go ahead and do something before the lobbying out there gets too big, so that we can, at the end of the day, we can protect our consumers. That's the whole point of this bill.
Thank you, Senator.
Thank you.
Senator from the 52nd, do you wish to ask a question?
Thank you, Mr. President. With Senator Yield,
Sure.
I apologize, as I think one other did, on this kind of not being on my radar, but I'm trying to catch up on it. So my first question is, this 10% is off of money they've earned,
Correct.
and then they would pay it back, and when would it be due? Is it when the paycheck comes in, or?
You know, Senator, I haven't really got into the business models. I think they're probably all a little bit different. I would imagine there'd be something within so many days of getting paid. To be honest, I don't know the answer to that.
Would the senator yield for
course.
another question? And so I'm concerned that with this 10%, let's say it's on a 2-week check and you pay it at the end, then the fact that you've paid 10% for 2 weeks is essentially 240% on an annual basis, and then we're getting into the payday loan category again.
Well, again, there's a cap on how much of your earned wage that you can actually access. So they already have policy caps on that.
So
within the industry, they cap the consumer themselves. Now, as far as that 10%, actually repeat your question if you don't mind.
Well, if you borrow this money and your paycheck comes in 2 weeks and you pay 10% in 2 weeks, then on an annual basis, that would be about 240% interest rate.
If you borrowed every single week, yes.
Right, if you kept staying ahead of it. So
Right.
it's to me in the
Right
in
now,
interest rate
right
higher
now, there's no cap. There's zero cap right now on what they can do. And again, you're talking about a mandatory fee. That's if they mandate, if the company mandates that you have to pay a fee. Currently, there is no business model in this state, is my understanding there's no business model in this state that has a mandatory fee. They're all the consumer elected fees. Again, we've defined them both in this bill. And so what we're trying to do is get these consumer protections in now so that we don't have any earned wage access service providers that are bad actors coming in and are doing these predatory type things that you're talking about. We're trying to do that now. Now, you may think 10% needs to be lower, and that's fair. I won't get into that, but 10% was what we could get the industry to agree to, and still have that consumer protection. If you're, and you got to understand, most of these consumers, when they're utilizing this service, you're talking about like $50, $50 to $100, maybe sometimes $20 and $30. And so that 10% came from, there is that expedited fee that we talked about that one company, or actually a couple of companies use, and it's a $2.99 expedited fee. And so that would allow them to get, loan a $30, or not loan, but allow the consumer to draw down $30, and they'd still be within that cap.
Well, if the senator would yield for one more question.
Sure.
Trying to get my wrap around this. So this isn't their company loaning them the money in advance. This is a third party lender loaning.
It is a third party that is allowing them to draw down the money, that the consumer to draw down money they have earned, and the third party acts as the bank. Correct. Except for one exception, there's no recourse on it. And so again, I can't emphasize enough, if right now this industry has no checks on it. And this is a way for us to come in and put some protections for our consumers. Maybe it doesn't go far enough, and it's probably an industry that we will probably be dealing with this year in and year out. And so this bill gives us a framework to work off moving forward. It gives us definitions within the industry that everybody clearly understands what it is. Well, I won't say we all clearly understand it, but at least within the industry, we're clearly defining it, and we're putting it in code so that moving forward, we've got a template to work off of versus just kind of flying at this thing blind. Now, because right now, many of y'all are seeing this for the first time, and it is very confusing. As former banking chairman, it was confusing to me last year when it first came to me, and that was why I've worked on it over the off session. I thought we were going to have a House bill that came over, and they ended up scrapping it, and so I'm all they got left. And really, us in this chamber, we're all consumers have for protections in an industry that is brand new. And so this bill, it's not complicated, but it is a very complicated industry when you're first hearing about it. So I tried to simplify it as much as possible, keeping the consumers number one, because many times out in that hallway, they're not getting paid by consumers. They're getting paid by a business. And so I wanted to put a bill together that did not put one company over another company, and I wanted to put a bill together that put a consumer first. And that's what this bill is about, and I would urge your favorable consideration. Are there any other questions? I'll yield for any more questions.
You probably want to go ahead and yield, Senator.
All right, I'll yield now. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 30 and the nays are 24. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Ooh, that's a perfect example about you almost oversold that one. So, I move, call on the Senator, the Majority Leader, Senator Frisbee first.
Thank you, Mr. President. After that stellar performance by our Rules Chairman, I move that we table the remaining bills on the calendar.
All right. The Majority Leader has moved that we table the remaining bills and call them up accordingly. Is there objection? Without objection, the motion is granted. So that our secretary can get everything in order, and the bills that we will be calling up moving forward, we'll be bringing off the table. So we're going to stand at ease for about 30 minutes so we can give our secretary and his staff time to organize the remaining of the calendar. Standing at ease.